go to a closing, you know, that's when everything culminates. And it's an important day for your clients. And a lot of times it's at the max stress level. So these ladies, they deal with people when they're maxed out. They have packed up for the last 3 days. Things didn't go well, or they did go well, but they're exhausted. They're tired. And so it takes a special bunch of people to be able to close these happily and help us get through that time. And so what we were noticing is even veteran agents, they weren't respectful of the title company's time. You know, they were scheduling walkthroughs 30 minutes before your closing or an hour before your closing. And that can be tight because right now in this market, especially, these closing companies, they are back-to-back closings. And so if you're late, then it delays them. So kind of keep that in mind. That was one of the things that we saw. And then a lot of people didn't realize, you know, how the title company works. What's their purpose? And like if you have an estate, if you have a special deal that you're going to list, they're a resource for you in the very beginning to reach out to check, to help you check title. You know, I've got one right now that's kind of a weird situation. And the lady is telling me that there's a quitclaim deed out there on her home and that her husband won't have to sign. Well, I'm not seeing that and she can't produce it. So I've got the title company helping me run a title search on that property before we even list it, because there's a little bit of a question mark there. So anyway, that's kind of where this class came from. We just felt like there was a need of even title company etiquette, you know, closing etiquette. When you walk into the closing room, where do people sit? You know, especially as new agents, you're like, I don't know. You know, you need to be thinking about who's going to be signing at this contract time. Should you be putting your seller who's not signing next to the closing agent? No, you need to have your signature people closest to the closing agent, and then you sit at the end, or you sit between, or wherever you need to be to advise. And, you know, hopefully we get this closing paperwork prior to sitting down at the closing table so that you can review it before you get there. Sometimes that doesn't always happen, as veteran agents know. Sometimes you don't get to see it till the last minute. There's been changes, and it just happens that way. It's very unfortunate sometimes, but sometimes that's the way it is when you're trying to push a closing through and the package just got to the title company that morning. So it can be really, really tricky for the title agents to get all that they need to get done. We would see that agents would come in and they would want to have a big conversation and talk over talk across the table because everybody's excited. And, you know, there is, like I said, that etiquette. We need to let the title company do their business first. And then, you know, there's always that lag of time at the end of closing where they're making copies. That's when we need to be talking across the table back and forth to let them get their job done. Again, with COVID, everything has changed. This particular Maryville office has experienced COVID personally. And so they are still doing closings outside. So when you come to the title company, you are parking outside, and they are bringing your title and your paperwork out to you, and then you'll sign outside. It's just different times, but typically as a buyer's agent or as a selling agent, make sure that when they come to the title company, they have at least 2 forms of ID. Typically buyers especially are required 2 forms of ID, their driver's license and some other form of ID. Sometimes sellers can get away with just the driver's license, but kind of have them prepared for that. And here comes Stephanie and Abby. So let me introduce you guys to the team in Maryville. You're going to sit right here. They're all shy. This is their first Zoom call. So this is Abby. Hi. Abby Borth and Stephanie. Just squeezing her, Stephanie.
Let's cuddle.
So we're not going to follow social distancing on this call. But
we don't. That ship is already sailed.
It's already
Can we hear them?
So yeah. So right now, so give us a second so I can introduce them. These are all the people on the call. Okay.
Can I see them?
It's struggled to see them. Hang on, let me see if I can show you guys. Let me see if I can show them.
There's our fans.
Yeah.
Yes, there they are.
All these folks. There's Bill. Look at Linda.
Oh, hey, girl.
So unless they unmute themselves, you won't be able to hear. Look, we even have a Jennifer Lopez. Jennifer, you're always on these calls. I appreciate
Jenny
that.
on the block.
J-Lo, yes.
So,
I love it.
And some people don't want to be seen. But
so we can't. So we're just talking to the computer.
you're kind of talking to the computer. It's not as fun the way we usually do it. So these ladies always have us. Let me see if I can get back to my screen. If they always have either some kind of breakfast item or mimosas, something wonderful when we show up, and it's just weird times right now and we don't like it. So we want to get back to the way we did things before.
Yes.
But anyway, I'm gonna let Abby and Stephanie start talking, and
Yeah, sure. Here, let's get on over here. There's a wall over here.
Okay, so they can see all these forms,
they can
right?
see the forms. Yes.
Okay, so what does a title company do? We make sure that the title to a piece of real estate is legitimate, and then we issue title insurance for that property. The attorney on staff, which is Susan Potter, I don't know, some of y'all might know her, but
And this grouping is from all of our offices, so some of them may use the Knoxville office too.
okay,
Hopefully,
And
by the
she
time
does-
this class is over, they're going to love you guys better.
Of
But
course,
no, I'm just
of
kidding.
course.
Becky's all-
Morning. Your audio is breaking out, girls.
What?
The audio is breaking out. I don't know.
audio is
Bill, are you having trouble with audio, or is it just maybe her?
I can hear okay. I think maybe.
You sound good on my end.
Okay.
Okay. Let me turn it up just a little bit, maybe. Okay.
and so Susan is the attorney, and she goes, once we get the contract, she goes to the courthouse and will search the property, and she goes back 30 years. And then the title insurance comes into play when you have a lender, or if it's a cash deal, the owner. And the owner, it basically protects your equity or your buyer's equity against lawsuits, claims against the property that result from disputes over the title, any heir that might try to come back on an estate, any kind of title issue that would jeopardize their equity or their investment in the property. Then instead of hiring their own attorney, then the title insurance, our underwriter and those attorneys basically figure out how to fix the problem without the buyers losing their property, is what title insurance is for. Then we will review all the title work from the attorney. Sometimes the title work comes back and there are issues that are on there. Currently, the only issue, which taxes are considered a lien on the property, but those are due now. So all of those are showing up for Blount County currently. And any other issues, we contact the list agent first and let them know that there are certain issues on the title that we have to clear before we can close. And then that way, everybody's kind of on the same page with all of that. And then we fix the issues. If the issue is not fixable, I guess, then we obviously let everyone know about that as well. And then our main job basically is to facilitate the closing between the buyers and the sellers and agents, lenders, everybody involved to get to the closing table on time per your contract closing date. And then we record paperwork in the county that the property is located. And that is basically, in a nutshell, minus all the other crazy things that we do during the day, what a title company does. And then we'll get more in depth as far as all the other things with the other forms that we'll go over this morning. Does anybody have any questions so far?
I do.
All right.
When is the best time to send over the contract for you guys to do the title searches and stuff? Is it as soon as we get the contract, or would you prefer to wait until after the inspection or appraisal, or?
No,
There's
we're
a
gonna
form
go
on
over.
that
Yeah,
somewhere.
we're gonna go over all that stuff too.
But the best, like we always say, so our title company is one of, I would say, a lot that don't charge for the title work. So if you send us a contract and then 3 days later the home inspection comes back bad or it didn't appraise out, y'all can't renegotiate a price, then we don't send you a bill for the title work or the work that we've already done. And that's just kind of one of the perks that we do, because we like to have everything as soon as possible so that we can get everything worked out And the longer we have it, the easier it is to do that.
Yeah, so we do charge for the title work, but if your file gets canceled, you don't get charged for that. It doesn't get
Okay, gotcha. Okay.
You only get charged if it closes. So the sooner you can get it to us, the better, is what we always say. We have some agents that say, hey, here's this one. I'm waiting on a seller's signature. They're elderly and I have to meet them in person. So it might take me a couple more days, but here it is. And I'll send you the seller's signature once I get it. And we're perfectly good with that anytime.
If it's something, you know, we have a lot of people, Donna being one of them. If you know that you're listing a property and there's problems coming up, and you know you've got people in the chain that are no longer with us, you know, the spouse may have passed away, or it's an estate, or any sort of issues that you see coming up, just as soon as you know that you've got something in the works, if you want us to go ahead and search that, if you anticipate there being issues, of course, you know, the faster that we can get started, the easier the process is.
Okay, thank you.
You're welcome. What's the next
All right,
one?
so the next screen that we have is just their information sheet that they'll send out to you.
Okay, so here, we'll use our office because obviously we're not exactly sure the precise processes of the other two offices. But here in Maryville, if you're going to send us an order, you can always send it to Stephanie or I, but Sarah here at our office at our front desk ultimately ends up with all the orders because she orders the title work from our attorneys. So you're going to send your contract into us. We're going to order title work. And then immediately once that title work gets ordered, either Ashley or Malia is going to send the list agent out the list agent sheet. And what that is, now, how do we go back up?
Scroll this way.
It's all so fancy. Go back to this.
Go back to this
Yeah.
one. Okay.
So this is the list agent sheet. And if you are the list agent, we just need everyone to fill this out as completely as possible. Again, this kind of goes back with what we were saying a minute ago. The most information we can have at the earliest possible point, the better we're going to do as far as being able to get things taken care of efficiently and quickly. The most important thing being that we need to know if it's going to be a mail out, if there's going to be, your people are not going to be there, whether it's the buyers, the sellers, one buyer, one seller. Those situations are always kind of tricky and they always come down to the last minute. So we need to make sure we can prepare for that as best we can. We need to know also if it is an estate, if there's anybody in, you know, any owners of the property that have passed away, if it's children that are now selling the property because their parents passed away, whatever that situation is, that we can address that. Homeowners association dues, and all this stuff is on there, but just fill this out as quickly as you can. Oftentimes we have to order homeowners association dues. Homeowners associations are often run by just someone who lives in the neighborhood. This is not their full-time job. They're not paying attention all the time to these requests. So it takes sometimes several days to get information back on those. We have to get your seller's payoff. So we'll need their contact information. At the point that we get this sheet back, either Ashley or Malia, and we're going to go down and give you everybody's job titles here at our office here in they will then order the payoffs, or they will call your and get their payoff information, being their account number, their mortgage company, and their social security numbers. And then we will order payoffs on those. And I've totally lost my train of thought. I was doing good.
Well, it's really hard, guys, for if you've
we
not
can't see, like, not being able to see people is very difficult.
It's hard. It is hard. And so again, reminding you, we're moving towards this title company staff. Knoxville staff is a little different. Is Becky the main closer there?
So at North, on Tazewell Pike, Becky is the main closer there. And then at Level Road, both Lisa Orr and Kim Harden close there. And then they obviously have their processors and support staff. So here at our office, Stephanie and I are the closers. We share files down the middle as they come in at random. I get one, she gets one, I get one, she gets one. You'll know going through the process, I think the girls send out an email and tell.
You do. Ashley, if
Yeah.
it's your listing agent, Ashley will send that listing information sheet and let you know who your closer is going to be. After you send the contract, Sarah or Ashley can always tell you who your closer is going to be. And, you know, that's, to me, that's one of the unique things about Southeast is that you go to some title companies and you never know who has the file. Like it goes from one person to the next person to the next person to the next person. And then when there's a problem, you really don't know who dropped the ball. With Southeast, the way they do it is, I think, very efficient, because once it gets past those preliminary steps, it goes to one of these closers that we've discussed, and they have that file. So they know what's going on in that file.
So now we recently, well, not recently, right before COVID happened, Malia joined our staff. So we basically are two teams, Malia and Stephanie. Stephanie's the closer, Malia is her processor, and then I'm a closer and Ashley is my processor. So that's who you're going to go to. But at all times, if you do not know if you're using us and you don't know where your file is or who has it, you can copy everybody that you know that has a Southeast title email address, and we will figure it out. We are the queen of deleting things that are not our problem. So if you send something to us and we don't know what you're talking about, but we know that the other one does, you know, we're good with that. Just make sure that, you know, if you send us an email, we're gonna get it. And we try to be as quick and efficient as possible with emails. Rarely, unless it's just absolutely insane, which it has been lately. But as a rule, you're never going to go more than hopefully a couple of hours without hearing back from us if you've emailed. Definitely not more than 24 hours, but usually pretty quickly.
And then back to the list agent sheet. So like we said, the more information you have, the better. Obviously we know that you all don't know what the dues are. So like some of our agents will put where it says HOA dues payable to, they'll just put ask seller, which is perfectly fine because normally the seller will have the contact information for the HOA contact anyway. So you don't have to wait until all of the list agent sheet information is filled out before you send it to us. If you don't know, just put don't know, ask seller. And then a lot of agents ask why we re-ask some of the questions that are on the contract. And that's just because many a times we will get down to the last, you know, the day before closing and somebody will say, well, seller paid closing costs were supposed to be this. So we just try to make sure that it's all unified going forward. So when we ask you again for the information, it's only just because we want to verify that there's no other addendums or repair agreements that we do not have.
And for like, especially for those of you that are new and haven't been doing this, as you get into having, especially when you have more than one deal at a time, a lot of times the title company kind of gets forgotten as far as sending amendments, sending repair amendments, sending those things. So yeah, at the beginning, you may not have had any seller paid closing costs, but now we're 3 or 4 weeks in and there's been an inspection and there needs to be all these repairs. You know, people don't want to do it. So they've agreed to pay $3,000 worth of seller paid closing costs, but nobody told us. And we get to the CD preparing part and suddenly your buyer's bringing $3,000 more than they thought they were supposed to be because it got forgotten. And that's okay. And it happens. But that's why if you feel like you're going through things and you've been asked 42 times, are there any seller paid closing costs? Are there any amendments? What about this? What about this? And you're thinking, I've already answered that. Well, you're going to come a time when you're getting asked the question and you're like, oh my gosh, I forgot to tell you. Yes, there is that is happening. The things, yes. So that's why, you know, a lot of times there's some repetition, just like when people are signing loan packages. I mean, they're signing the same things over and over again because we do as much checks and balances and checking each other as we can. And even at that, sometimes we get down to the last minute and there's still things that we're struggling around to find and everything, but that's okay. That's the nature of the beast.
Any questions?
I can hear good. Everybody's hearing good. Okay, great.
I have a question.
Okay.
Sure. So it's like an estate question about titles. So my aunt passed away on August the 8th, and her home will be ending up in mine and my sister's hands. My question is, for us to be able to sell her home, how many weeks is it that you have to wait before that process can happen? We're starting the probate process. Is it so many days from probate for a person?
If you can hang tight, we're going to go over all
okay.
the estate.
Perfect.
So, great
Sorry,
question.
guys.
No, it's great. And actually,
That's
to
a good question.
talk, it's
Okay.
a great question, but we are going to get to it. There's a whole section today on estate. So we will.
Yay, okay. Perfect. Thanks, girls.
Okay, so the next thing that we have on here, and again, you know, we do this as Southeast Title. I don't know, I'm sure that you guys know this, but it is the buyer's choice as to who the title company is. Now, that being said, the seller also has the right to choose to use their own title company for their own side. So if you're doing a contract and you put in your contract that you would like Southeast Title to close, and your seller comes back and says, I'm not closing with Southeast Title, I would prefer to use ABC Title, and you are dead set on using Southeast, your seller may choose to use ABC Title to represent them. Stephanie loves a split closing. I would prefer that everyone use Southeast Title, but I don't always get what I want. So a lot of times we do have those split closings, and that's fine. But legally, your buyer gets to choose who they are going to use for their title company. So what we're going through today is our prices, our fees, our processes, but we obviously can't speak for all the title companies, and you will end up using other title companies other than us, as bad as we hate to say that. So these are our closing fees, and honestly, we're really not blowing smoke, and we have this conversation a lot. You're probably not going to find a title company around here that's any cheaper than us. Would you agree?
Nope, I would agree. And I would also, even if you're not using Southeast, keep this if you're a new agent and you're doing a net sheet. These are very, very handy fees to plug in to your net sheet for your buyer or your seller to see, because, you know, within, I would say $50, all of these are probably within $50 range of other title companies. You know, if it's a company that you have never heard of, it pays to make that phone call to say, hey, what are the fees? Because you know, some places that I've been, it's like, what? They're charging us $200 for that? Well, that was for the little bundt cakes and the champagne that they had at the closing table. I mean, you know, it's kind of crazy what can be added on, but these are the basic fees for most title companies. And like Abby said, Southeast is very, very, very affordable. And I would say that if you're going to use these, you can kind of estimate that it could be anywhere $50 higher on each of these at other title companies, and you'd still be pretty safe.
And also, again, and this is, we would always prefer you use Southeast Title, but if you get backed into a corner and you're using somebody you're not familiar with and you feel like they're knocking you out of the park, send them this sheet and say, this is what, you know, this is, I know that I can get this done for this. My buyer is dead set on using you, even though I would prefer that they use my best friends at Southeast Title. These are the fees. Can you match these fees? I mean, we know.
And we don't advertise that either, but that we have plenty of people that will send us stuff and say, hey, I've got this one thing going on. Can you all reduce the buyer's cost, you know, by 20%? Or can you cut out their closing fee or this or that? Like I said, we don't really advertise it, but we'll work with you all and your buyers or sellers or whoever that we need to, just to make the process easier on everybody.
I'm sweating. Now I'm freezing in here.
Yeah, I'll get you.
So the fees for the closing fee, and again, sometimes you'll just have, you know, obviously you're just gonna have your buyers or your seller. Sometimes you'll be the agent for both, but closing fee on each side, $150, doc prep $150, title search is $250 if the property is in any county other than Knox. Okay, if your property is in Knox County, the fee that your buyer is going to pay for the insurance, for the title insurance, is going to include the title exam. So they will not have that $250 charge. However, the title insurance charges will be higher because they include that $250. So it all ends up working out to be the same. Your wire fee is going to be $45. And then usually there's a courier fee that's $45. And those fees are because every package, every closing that we have in this office, we have to FedEx the entire loan package back to the lender. Payoffs, we either have to wire those out or FedEx the paper check to the lender. And obviously we have to pay for the FedEx every time that we do those things. And we have wire fees that are charged through our escrow account. Then you will have your title insurance, lender's title insurance. Again, for Blount County and all other counties, does not include the exam. Knox County includes the exam. That's going to be based on your loan amount, okay? So your lender's title insurance is based on the loan amount. You are not going to know that amount. Your lender is going to be the one that's going to be really quoting fees for all that. So you don't really have to worry about that as much. Owner's title insurance. If you have a cash deal, we always encourage everybody to purchase owner's title insurance, period. Especially if you have a cash deal, owner's title insurance covers your equity. So obviously if they're paying cash, they've got 100% equity right up front. If the property is coming out of a foreclosure, a divorce, an estate, any of those reasons, we always encourage owner's title insurance. If they're purchasing a lender's policy anyway, so if your person is getting a loan, the owner's title policy is only $50. It's automatically included on the closing statement. You don't have to worry about it. If it is an owner's a cash purchase, we always, when we send out the settlement statement, we include the owner's title policy charge. They do have the right to refuse that though. And sometimes people are going to be like, hey, what's this $800 for? Hey, what's this $1,400 for? And that's when you're going to explain to them. Owner's title insurance covers you in the event that anything unforeseen happens to the title of the property. If something was incorrectly recorded, if something was incorrectly referenced at the courthouse, you know, if anything, any title company along the way didn't handle something that they shouldn't have handled, and an issue came up because of that, and you ended up in court, or someone came back on your property, owner's title insurance would protect your equity and cover any court costs and attorney's fees that would be associated with anything like that.
Even after you sell the property, correct? Like we had one not too long ago I had one with Stephanie where I think we closed maybe 8 years ago.
Right.
And my buyer had purchased title insurance, and it's conveyed, I think, twice, but there was an issue with title, and you know, basically he had coverage to protect his interests, and his attorney fees were covered. So, and
the way that on cash deals, the way we always explain it for owner's title insurance is it's always cheaper than paying a retainer fee to any attorney in Tennessee.
Yeah.
It's usually less than that. So it's always just a good idea. And then we've got brochures here from our underwriter on it. We've got printouts. So if y'all ever need any other information, documents on that, we can always email them over to you. You can come by the office and pick them up. We've got all kinds of resources for stuff if you all.
And my thing that I always tell everybody about owner's title insurance, it's just like any other insurance that you're purchasing, health insurance, car insurance, home warranties that you buy for your property. It may be something that you never have to use, but if you did have to use it, it would pay off so substantially that it would be worth the risk of you paying for it up front. So, you know, that's just something, it's just a really good idea, because anything that involves attorneys is expensive. So, okay.
All right.
Hey, Lynn. Hey, girl.
Oh, there is sweet
She's
Lynn.
talking now. We can't hear.
I said I'd take a phone call, but I'm back.
We
missed
glad you're back.
All right, steps. What do? You're a new agent, and you know it's amazing that even veteran agents forget to do this. But typically, like she said earlier, once you get a contract, it's time to send it. Don't depend on your lenders. I mean, they're going to, but sometimes they don't send it till too late in the game. So go ahead and send your contract over. So I'll let Abby back. Go ahead.
Yeah, you know, we talked about that earlier. Just as fast as you can get it to us, as you get your additions to the contract, your amendments, your addendums, your counters, your all the things. Send. We do not need your VA, FHA amendment things, it's okay. Send them. We don't need your compensation agreements. It's all right. Just get in the habit of, if you're sending it to somebody else, if you've got it signed, send it to us. We can delete if we need to, but we would rather have all the things and need 2 of them than have none of the things and need 2 of them. Okay. So,
And there used to be a time when termite letters were always required. I think now they're only required on VA loans. However, with that said, depending on the lender is whenever they require a termite inspection, this lender doesn't. So we will not ask you for the termite letter ever, because it's just not something that, unless the lender is telling us like, hey, we need the termite letter, you won't hear from us on the termite letter. So once which we'll go over the steps in this, but kind of like once we've got everything finalized with the lender, if you come back in and say, oh, well, we have this termite inspection we need to add
for $50,
we're not gonna be able to add it, just because it'll have to go back to underwriting, it'll have to do this. So if you get that up front and send it to us, obviously we'll put it in the file and get it taken care of. But that stuff and repair amendments, counters, stuff like that, we're not gonna know to ask you all for that information. We've gotten, some files where the lender will send us the final numbers to approve and the sales price will be different. So then we can ask them for the counter, but it's just a whole lot smoother process for everyone if we get everything up front. So that, and also, we also know you probably don't want to send repair amendments to your lender. There's some things that y'all don't send to them. You can send everything to us. We don't care.
For the people who are newer and who are not veteran agents, okay, so a lot of times you're going to do repair amendments. And on these repair amendments, they're going to be like, oh, leaky faucet, patch on the roof. This is what we're going to do, blah, blah, blah. A lot of times, everyone involved does not want the lender to be aware of these things, because this sends up red flags like crazy, that the appraiser missed something, that there could be an issue, that blah, blah, blah. And then that's going to set it, that's going to stop them dead in their tracks and cause them to go and review things and do all the things. So we know a lot of times that some of these documents, mainly repair amendments, do not need to go to the lenders. Okay. It is going to be up to you and your discretion as to whether or not you send those to them. But us personally, we aren't sending a repair amendment to a lender. If you feel like that's something that you are going to do, that's up to you. But a lot of times you're not going to do that. Like, I don't know how to explain that better. Help me.
Well, I mean, typically, and we teach this sometimes in the contract class, if, like she said, maybe there's a repair that needs to happen on the roof, but it's not so significant that it should stop your closing. However, to a lender, a roof is a big, big item, and it will cause that red flag. So you may have, not to be deceptive to the lenders, but a lot of your lenders will say don't send it. But if you send it to them, they're made aware, then it becomes an issue. So just be very cautious. I would suggest when you get your contract, bound, go ahead, if there is a loan involved, add the lender to your loop. Go ahead and add Sarah to your loop. And then once you find out your closer, add your closer to the loop. So when you get an amendment or an addendum that is going to the lender, you can actually send that to the lender and the title company at the same time. But like Abby says, maybe you're going to send, my preference is if you do a repair amendment that says we're in lieu of this repair, we're going to pay $500 towards seller's closing costs, or I'm sorry, buyer's closing costs and prepaids. So then I would do a different amendment to the contract. So not only would I have the repair amendment, but I would do an amendment to the contract that just says seller to pay $500 towards buyer's prepaids and closing costs. It's not going to say why you made that change. It's just a flat statement changing that item. That amendment will go to the lender. And that's, honestly, that amendment can go to the title company. Because like they said, they don't care why it's there. They just need to know so that they can balance up that closing sheet.
Yeah, we care about the money. We don't, and I don't mean for this to sound as mean as it sounds, but we don't care about your repairs. We don't care about any of those things. We care about how the money is working out. We have people ask us a lot of times, well, what about this? Well, we don't know. That's not our section. Yeah, we need to know the bottom line, how much your people are paying in closing costs, how much we're deducting, if there's problems, we've lowered the sales price, if, whatever, we've raised the sales price, all the things. Home warranty, anything that's money related is what we need to know about. But again, we would rather you send us things that we don't need to know about, and we can discern whether we need those things or not. Something else along the lines of that, oftentimes if you are the list agent and there is a repair that's had to be done on the settlement statement, some title companies, and we've done this in the past too, but we've pretty much gotten out of it, will put on the line item, let's say you're paying $2,500 for roof repair. They will put roof repair to Mr. Roofer, $2,500. We now just put invoice, because it's nobody's business what we're doing. Invoice to Mr. Roofer for $2,500. That may mean to them that they've done something special to upgrade the roof. They don't need to know that we had to repair the roof. The lender doesn't. Okay? Because we want the lender to be as secure as they can feel about giving your buyer this money. Because if they're not secure and they don't feel good about it, they won't give it to them. Or they will give it to them and it will take us an additional 3 weeks. So,
yeah. And then they'll ask for other inspections, and then which will cost more money to the buyer. And so it's kind of like that rabbit hole you don't want to.
Yeah, it's really frustrating. I've had lately a couple of lenders that did ask for the home inspection, and I'm like, why? What's the point? And I know we may have Scott on here, a broker. I don't know what your opinion, but that's really frustrating to me. To me, it's not the lender's. I don't know. It's just frustrating to have somebody request a full inspection when. Anyway,
their appraiser should take care of,
yeah.
Okay. Do we want to see if there's any questions? How we do that?
Okay.
There's none at the bottom that I see.
Okay. All right. Good deal. It would show up right there. Okay. Good deal. All right. Things we need from the listing agent. So you're a listing agent. You've got a contract now. So, and some of this on the listing side is before you can do a little bit of work before you ever get a contract.
Right. And then, correct. And then kind of along the same lines that we touched on, whether you're the buyer's agent, the list agent, once you go binding and you know which title company you're closing at, send it to the title company. Sometimes the buyer's agent doesn't always send it. They think the list agent's going to send it. Why, I don't really know, but we've come into that before. So if you have a binding contract, just send it wherever it's going. If 2 people are on title and only one signs the contract, we're going to automatically need to know where the other individual is. If they are, there's Bill's cat.
Sorry about that.
Listen, I have unmedicated ADD. You can't be distracting me like this.
I told Donna to go ahead and mute her, but she still likes to make noise.
We need the noise. We can't. It's hard. It's hard to just be talking to the computer.
Like Lynn's loving this. Okay, so squirrel.
So again, when you list a property and your first line of information is going to CRS or reaching out to the Register of Deeds and pulling that deed, if you notice there are 2 people on the deed or 2 people on the tax record as an owner, but you're only dealing with one, Stephanie is right. You need to be asking, so where is the other person? And, like I told you earlier today, working on this one with this lady, she keeps telling me that the husband has no right to sign or no right to sell. He's already moved on. Well, the title is not showing that. So we've got to have something to say that there is a quitclaim deed out there somewhere giving her the right to sell without him.
Yeah, the mad ex-wife, ex-girlfriend doesn't get to make these decisions. Unfortunately,
it's a legal issue.
Just because she's real mad at him does not mean he doesn't have
Which
to do.
Which is fine. And we know, like, some of, especially the newer agents, they don't want to have those awkward conversations with their client, which is completely fine. We can have that with them and be extremely nice about it, but point blank as far as what the facts are legally. So we hate CRS, and let me give a really good example of why we hate it. So I had an
Look at
agent-
Bill.
I
Bill's
know,
already
Bill's
like, oh Lord, here they
But-
go.
I had an agent that called me this week and said, hey, I'm getting ready to go list this house. It shows on CRS that they don't own it, that it was transferred out of their name. I was like, well, that's a problem. So let me look it up. So we went to the courthouse, looked it up, and CRS had just put in the wrong deed information, which happens a lot.
So the courthouse retrieval services systems, whatever it is, from our understanding, is actually a lady or a person who is at the courthouse that manually enters this information. Maybe not anymore, now that things are so much more
It's
automated.
truly not the courthouse. She's just giving data and adding it
Right.
to, it's a system that we can use. It's not actually courthouse.
So we don't use it because it's not always accurate. However, it's better than y'all not having anything.
Right.
Okay. So if that is your resource that you have, you can go ahead and use it. It may at least alert you to issues if there are any up front, but we're not going to use that for the end all be all bottom line for anything ever. But it is there as a resource to you. Just know that oftentimes or occasionally it cannot be exactly accurate.
And I can send y'all the free link of what we use if you want.
So I want to say, kind of pop in here, this especially comes into play when someone has passed away. And like Abby and Stephanie said, maybe it's an awkward conversation to have, but they've asked you to come to their house to help them get it sold. And so you need to be able to broach that subject. So I noticed that so-and-so is on the deed. Is so-and-so still living? Has he moved somewhere? Whatever. Because this is going to be important for us to sell. And once you make that conversation start to happen, if they have passed away, you know, it's a good time to go ahead and prepare them that when we do sell, we're going to have that death certificate. So if that's something that you don't have now, you can be working on that. But it's real important to ask that, because y'all, we can't make this stuff up. But Abby had somebody come in maybe a couple of years ago to sign, and the entire time that they did the contract and did the process, they thought Mr. So-and-so was alive. And when they got to the closing table and asked, you know, are you Mr. So-and-so? They were like, no, he's dead. I mean,
okay, and this has happened like more than once. So, and the thing that we always say, or I always say it, there is no database where we can go and check every name to see if they're dead or alive. Like there's no magical dead person website other than searching obituaries, which we cannot do that for everything that happens. So I have gotten to closing before. The entire, 30, 45 days that we have been working on this, with the assumption that Mr. and Mrs. Smith are the sellers. We get to closing, the deed's prepared for Mr. and Mrs. Smith to sell the property. All the documents have Mr. and Mrs. Smith. The list agent loved their little hearts, never one time has said one thing about Mr. and Mrs. Smith other than the fact that they are selling this property. And we get to closing and there's only a Mr. Smith. And so I'm like, hey, where's your wife? She coming? She in the bathroom? What's up? And he's like, well, she died in 2012. There is no way for us to know that unless y'all tell us. Period. End of story. We have to have the information that you have. You have to, as the list agent, it is part of your responsibility to find out these things. Just like Donna said, if you get there and you've looked at CRS or court or whatever, and you pulled the deed or whatever, and Mr. and Miss Smith are both on there, and you get to the listing appointment and only Mr. Smith is there,
or a child, or
yeah, or
grown adult
or
child.
the deed says 1965, and you get there and it's a 40-year-old that's going to sell the property. Clearly, something has gone awry in some way, somewhere. So you've got to find out.
And dead people cannot electronically sign your contract.
And you can't be a power of
valid.
attorney for a dead person.
That's exactly right. So I'm going to stop in here for dot loop.
We get really
as dot loop users, we have started to put into our contracts the two deceased people's names or the one deceased person's name. When there are no living people left, it is no longer owned by those people. It is an estate of those people. So in dot loop, you can actually put as the seller the estate of Bill and Betty Booth, okay? But then you're gonna also put in whoever's going to sign, like that's maybe an executor or I don't know, maybe they've an attorney that's signing on behalf of the estate. You can still add that person as a signature, you know, to have a signature spot, and you're just going to manually assign where they sign. Abby and Stephanie get it every day where somebody has signed as the estate of, or Bill and Betty Boop who have died. And that's just, like they said, a dead person cannot sign electronically. But we've got it happening through Dotloop. So make sure that you are putting the estate of and then whoever is supposed to sign. And guys, another note, POAs go away when someone dies. POAs are for people who are living, and they can talk. They'll talk a little bit more about POA. But you don't. If you have somebody like a adult son who says, "I have the POA for my parents' estate," well, if they're dead, the POA goes away. So they're, you know, it's always a good idea if they have documentation on having the right to sign, send it over to the title company. They can let the attorney look at it to see if it's actually the proper document to sell.
And a lot of times you're going to have so you have an estate, you get there, it's a son. Clearly, you know, you all have discussed it. Mr. and Miss Smith are your sellers. Now we have a son there, and he is going to sign as the designated signer for the estate of Mr. and Mrs. Smith. In the process of doing the title work, we've realized that maybe he's not the right person that needs to sign, or maybe he needs to sign and a couple siblings need to sign, and that's all right. We can make all those adjustments. You know, if need be, y'all can do amendments or addendums or all the things. But we're going to tell you once we get the title work done and the deed prepared, who all is going to have to be at closing. And a lot of times that's going to put us back in a situation where one brother's in California, one sister's in Kentucky. We have somebody that lives here.
One's in prison.
One of the brothers has, one of the brothers has died, and he has 3 kids, and they live in 3 different places. So that's, again, another reason that we need to know this estate stuff as soon as we can, because it just gets deeper and deeper and deeper into dealing with lots of things that are totally out of our control, but that have to be handled with expediency.
Enough talking about
divorce. Yeah, let's talk about divorces. Let's get a little bit happier. So divorce situations, some of the times if they have already been through the divorce, one of the parties will have signed a quitclaim deed, but then, which will remove their interest in the property. But then in their divorce papers, they said, Mrs. Smith will sign a quitclaim deed, but once the property is sold, then Mrs. Smith gets $35,000. So any divorce situation, which again, sometimes are difficult to have the conversation, the easiest thing for you all to do is just to let us know it's a divorce situation, give us the contact information for the seller, and then we'll let them know what we need. We're 100% always going to need their divorce papers. They might not feel comfortable giving that to you, which is fine. We'll ask for it. If they do feel comfortable giving it to you all can get it up front and then send it to us. Or if you know who their attorneys are, you can send us that information. Again, it's kind of just an informational thing. Let us know that they're either going through a divorce, they are divorced, and then contact information for how we can get what we need. And then it's kind of like with the estate stuff. Your all's job at that point, the list agent's job at that point, is to let your sellers know, obviously, like, thanks for the information. The title company will be in contact to let you know what else they need. And then just kind of push them along and make sure that they're getting us what we need. Kind of be our support system for that. Someone's
email you guys.
Yeah.
Okay.
So, and that information, we deal with a lot of files during the day, and we're in and out of files. We're in and out of this, but we're always usually sitting at our computer unless we're at the closing table. So the easiest way for you to get us all the information is in an email. And then that way we can print it out, go back and reference it. If we have questions, we don't have to call you back and say, wait a second now, what did you say about so-and-so and who? So any information you have, just send it to us in an email, and then if we have other questions, obviously we'll reply back to it. But that's really the easiest way for us to get all of that info from there.
And, you know, as far as the email thing goes, it's also important for you to have a record of what you said and what we replied, as well as for us to have a record of what you said and what we replied. Because we have been closing over, in this office alone, we have, for the last 3 months, have closed over 100 files a month. Okay, so we've closed 320 something files since the beginning of June. That is a lot of closings. That is a lot of conversations with a lot of agents and buyers and sellers and lenders. So it is always best for everybody if we can, even if you do call and we talk about it, follow it up with an email, just so we have record of what we've talked about, that we can, you know, either go back and search for that email, physically print it and put it in the file, so we all know that we're all on the same page.
All right, buyer's agents, what are you supposed to do?
Again, the termite letter, we have in our, so Stephanie and I have both been closing mortgage loans or in this business since the very early 2000s. So a long time for us. So there have been times that we have spent lots of time searching down termite letters, and that's no longer part of what we have to do anymore, because like Stephanie said, they're not required on all loans. So as the buyer's agent, if you have a termite letter and you want it collected on the settlement statement, it is your responsibility to get that to us long before the closing disclosure is ever completed. If it happens that way, we will get it on the closing disclosure. It will be paid through closing. If not, your buyer will be responsible for paying the $40, $50, $60 termite letter outside of closing. Okay. It is your responsibility. And we ask for all these things. If you don't get, you know, if you don't know this up front or you haven't provided it for us, we will ask. It is part of our, the attorney sends us a title exam that has a list of questions on it that she needs to clarify everything. And she often asks us, you know, if there is a young couple that's buying a property and they have 2 different last names, what's their situation? Are they both unmarried? Do they plan on staying unmarried? Are they getting, or did they sign the contract as unmarried, but by the time we close, they're going to be married? So we need to know the marital statuses of your buyers. Okay.
There was the question regarding termite. Basically, somebody asked, do you need a termite letter on a vacant lot? No. And a lot of, you know, if you've got a new construction, you're not going to have a termite letter. You're usually going to have a soil treatment. And the soil treatment letter is going to cover you for, you know, for a certain period of time. Usually it's a year, I think, just like a termite letter. But the soil treatment is going to be what the builder does, and some of them are not doing the same soil treatment like they used to. Now they're going ahead and installing the Centricon systems. But if you think about it, on a vacant lot, I mean, most likely there's termites probably. We're in East Tennessee. There's probably some termites somewhere on that vacant lot, so it'd be kind of hard to test for that. But there's really no damage that could be done to the property if there's not a dwelling on it. So we're concerned with termites and dwellings, not necessarily just termites being out there in the open field. So not a bad question, unless you ask, you don't know. So, okay. So yeah, Abby's talking about.
Okay, so another thing, as far as the buyer's agent, a lot of times we will have 2 people with the same last name who are not married buying a property. Okay, so Donna Morton and Morton are buying a piece of property, and the whole time we think Donna and Phil are husband and wife. So we do everything Donna and Phil, husband and wife, and we get here and Donna is the mama and Phil is the son. Okay, so again, as much information as you can provide us with, even if it's just a little email to say, hey, by the way, or when you send in the contract, hey, heads up, Donna and Phil, husband and son, or Donna is the mom and Phil is her son-in-law, and there's also going to be a daughter who's involved, but she's probably not going to be on the, you know, whatever. Like the most, am I yelling? I feel like I'm yelling.
Oh, you're good.
I'm deaf.
But basically, they need to
Just
know
mister.
all that information ahead of time because you know the client, they don't know the client. So you have to make sure. And, you know, if they're married, sometimes on the deed section of the contract, I will put married. If it's a brother and sister, I will definitely separate their names as, you know, Billy Bob and Mary Sue. And I've got their last names completely separate. And then I tell Abby or Stephanie, hey, this is a brother and sister buying this property. And sometimes you'll end up with two people with the same last name, Jones, and they're just investors together. So it's definitely important to let her know who is who on that contract.
And the other thing is too, it inevitably happens that if we have one Jones that's closing, we have 4 different Jones files totally unrelated to each other. So when you call in or you email us, in your subject of your email, please reference your buyer's name or your seller's name and the property address. We do not know what you're talking about unless you tell us. Oftentimes we'll get an email that says, hey, for that one on Sunday or on Friday, can such and such, we don't know. We have 18 scheduled on Friday. We don't know which one you're talking about. Or when you call in, you know, even our people that we know well, you know, if Donna called in and she didn't say, hey, on Rockingham, blah, 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 I would have no idea what she was talking about if she just called and started going into something. So make sure when you're contacting us that you reference what your property is or your buyer's name or whatever, so we know what you're talking about.
And as an added thing, if you message them through Dotloop, it's always going to send them, you know, it's going to tell them what address the property is automatically. So that's just a good habit to get in, is message them through Dotloop. Even if, and don't forget, you don't have to be sending a document in Dotloop to send a message. I mean, Abby and I message all day long through Dotloop, just on the messenger. So,
and when you're sending in a contract, you know, you have the ability to put a message in there when you're sending the new contract. So that's a good time if you're sending in something and there's special circumstances, you know, husband or mother and son buying, dead people, divorced people, just put a note in there. Hey, you know, by the way, my buyer, blah, 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 my seller, blah, blah, blah. And that way we print all that off and it goes in the file from the very beginning. So that way we have that information. Yeah, and the lender information if you know that up front.
Okay.
All right.
We do have a question.
Okay.
Laura Ann Hall asked if they aren't married when they purchase the home but get married later, do they need to change the names on the deed?
Okay, so in the state of Tennessee, the law is that you have marital rights to the property if it's your primary residence. So let's say that Jill and Jimmy buy the property as Jill Smith and Jimmy Jones. They are engaged to be married. They buy the property, it closes, they get married. The title to the property will still say Jimmy Jones unmarried and Jill, Smith unmarried, whatever. If they are married and it is their primary residence and they both live there, then they don't have to change anything unless in their little hearts they just want it to say that they are married and in love.
And we have a lot of people that do that. They just want it titled their married name, and which is perfectly fine.
They just feel better about it.
Yeah, they can call us after they get married. We can prepare the deed. It's $12 to record. It's not a big deal, but legally they do not have to.
Legally, once they get married, they own that property as husband and wife. Mm-hmm. So if one of them were to pass away, the property goes in its entirety to the other. Okay.
Unless the deed states otherwise.
Unless their will says something.
Unless their will says otherwise. Yeah. If they own the property, if Jimmy Jones buys it unmarried and then he marries Jill and him and Jill live in that property together, once that property goes to be sold, if he and Jill are still married and we have no divorce documents or anything like that to show that they have divorced, he and Jill will both have to sign to sell that property because they have occupied that property as their marital residence. So she has rights to that property just as he does because they were married, even though she was not a part of the purchase of that property. Once they got married and she moved in there and they spent their first night together as a married couple in that property as their primary residence, she has marital rights to that property.
Marital rights, though, as I've learned this year, doesn't necessarily mean you have all that's, I mean, it doesn't automatically go to you.
No.
I had the situation, we've talked about this, if you've been on the previous classes, Pat even talked about it on the contract class. I had the home where the husband was deceased, and the wife thought that this was her marital home and she would be selling it to get the equity. Come to find out, he died without a will, and she was on the warranty deeds. So she was on the loan, but she was not on the deed when they bought the house as a married couple. So she only, yes, she has to sign to sell it, but also the two older adult sons, his sons were also. So basically she had a child's interest in the property, not a marital interest.
So basically
not
what marital interest means is that if you have married someone and you move into that property and that is serving as your primary residence, your spouse cannot go and sell it out from underneath you without you knowing it. Okay? That's what happened. It doesn't mean that you get half the money. It doesn't mean anything like that. It means that your property cannot, the property that you are occupying as your home cannot be sold without you knowing about it. You have to sign off on that sale, basically.
I have a question, ladies.
Okay.
What about they were married and they bought the property where they already married, but it's only the husband shows up in the title or the deed?
Do they live there, or is it an investment property?
They live there. Say they lived there for 7 years already.
And are they still married?
Yes.
Then they both have to sign to sell the property.
Okay. Thank you.
If the question had been that it was an investment property,
it
may or may not.
Yeah. So if you purchase, if me and Stephanie are married and I purchase marital property, Abby Borough married, or I purchase investment property, that is my property that I own by myself. She does not have to sign to sell it. Okay. If it's investment property. If we are married and I buy property as Abby married, then she does have to sign to sell it if it's our residence where we live.
So in other words, the wife has rights to the property, even if it's not shown the name and the deed on the title company.
Yeah, as long as it's their primary residence together,
Yes.
she has an interest in the property.
Now,
Okay,
if he owned a property and he lived there by himself, and they got married and they bought a private property, and then they bought another property together, and that's their marital home, then this becomes an investment, and she doesn't have any right to it because she never lived there. See what I'm saying? They have to live there together. That's to be where they sleep in order for her to have marital interest in it, like every night.
Do you recommend to go to the title company and put her name on it?
Not unless, I mean, that's kind of what we were saying just a minute ago. Unless it just makes her feel better, it does not have to be done that way. Now, if they're concerned that one of them is going to pass away and that would clear up some issues with who the property would go to, then by all means they can come and add her as his wife, and that would 100% say that if he died, the property would immediately go all to her. But as far as if she's worried he's going to sell it out from under her, he can't do that without her signing off.
Okay, thank you.
And Laura, you asked if they aren't married when they purchase the home but get married later, do they need to change the name on the deed? They don't. But when you go to sell that property, even though there's only one person, you know, technically you can list that property and only get the person who purchased the home to sign that. But in order to sell, when they go to closing, they're all going to have to sign. So it's probably a good idea to go ahead and get both parties to sign, even the listing docs, the contract docs. But technically, you could do a listing and a contract without that person signing, but at closing, that other person would have to sign.
And if they bought the property as two unmarried people and they've gotten married and they just want to change it because her name has changed, you don't have to. She's still the same person that she was when her name was Jones before it was Smith. So you do not have to do that. You can if it makes you feel better, but you do not have to do that.
Okay.
Any other questions on the buyer's agent side?
Also, am I yelling?
Bill, does it sound like she's yelling?
No.
No, I think that's good. Yeah, anything else
It
you would?
always sounds like she's yelling.
I know. I usually am yelling.
We're not having that sound issue anymore, obviously. Bill, is there anything else you would want to add that the buyer's responsibility is towards the title company and preparing contracts?
No, I think you've done just fine.
All right, seller, what do you bring to closing?
The seller is going to bring their driver's license, preferably one that is not expired. And that again is just to prove that whoever they say they are that's selling the property, that owns the property, is who is signing the documents to sell that. They will bring a voided check. For this has a written wiring instructions. That's not right. Anyway, so now I don't know when I typed all these, but originally we could accept written wiring instructions. Now we can't. There's so much wire fraud that happens that we have to have a voided check in order to wire the seller's proceeds. If they prefer their proceeds to be wired instead of us just giving them an escrow check at closing. So that's kind of one of those things that's non-negotiable. We either have a voided check, they either have a voided check, or they don't. So we have to have that in our file. And then if it's going to, we have a bunch of people that will sell with us and then go and purchase with a different title company. And when they do that, we usually contact the other title company that they're going to and get their wiring instructions from them. And then we can wire their proceeds to the other title company for their closing. And then seller side CD is always provided by the title company before closing. We like to send those out as soon as possible, but our policy is that we do not send you the seller side CD until we have the buyer's package. And the reason we do that is we've spent, like Abby said, we've been in this for 20 years or such. So it is really hard to get, once we send that CD out and you show it to your sellers, they get real excited about what the amount they're getting back. Let's say it doesn't close on the day it's supposed to close, so their proration of taxes will change. Even though it's a couple of dollars, sometimes it's more than that, they still get really angry with us. Not with you all, but they get mad at us because their figures have changed. And we've heard, I don't know how many times, well, you sent me this should be final. So our policy here is just not to send out that seller side CD to you all until we have the buyer's package and everything's approved and we know it's actually going to close. Payoffs can change based on your closing date. And then there are, y'all cannot have side conversations.
Sorry, let me stop because it's distracting Stephanie. But Daryl's on this call and he does make a valid point here. Going back to if you have somebody on a deed, now they're married, yeah, it's definitely a best practice to get both parties to sign because you don't want one to blow up and then disagree with, signing at closing. So if both parties have signed the contract, they're bound to that contract. So it is a good idea when you're listing property to get both parties to sign, even if only one was originally on the deed, if they're married now. So just to clarify that, I hope that helps Daryl, but it's definitely a best practice you will run into agents who don't, but I think to protect your clients the best and so that you don't have an issue between the time that they, heaven forbid they find out that their spouse is cheating on them and then they decide, hey, I'm not going to go to closing and sign that document. So they're not going to sell this house. So Daryl's right. We really do need to be getting both signatures if they have interest. Okay.
And then back with the seller side CD. So once we send that CD to you and it's finalized and you all approve it, you all are required to send that to your seller. We do not send it to your seller. You all will send that to them. And then if they have any questions, obviously they can call us if you all can't answer that. The only reason we don't send that out is, like Abby said, we close probably anywhere from 80 to 100 regardless any month. So if we're sending out seller side CDs, they're sending us back emails with questions and questions and questions, then it's just a big, huge mess.
Something that we always tell these classes that is important for you guys to hear is that your customers have a relationship with you. Okay. And I know Bill and Donna agree with us on the way that we say this and what we mean when we say this. We are the title company. We kind of show up at the end and swoop in, and we want to take their money, number one. So they're already leery of us because we are the money people, but they have a relationship with you. So a lot of times you're going to get down to the end, and we get a lot of emails from agents, and they'll be like, my buyer has not heard a single word from you. Well, that's good news. You know, you are their person that has a relationship with them, that is guiding them on this journey of buying or selling their home. We are only going to reach out to your people if we need something from them that you have not provided for us, basically. If we have a question that you don't know the answer to, we've asked you and you either didn't know, felt uncomfortable asking them, whatever, we are more than happy to reach out. If it's something that you feel like they have questions about that only we can answer, or they would feel better hearing it from us, obviously we'll reach out to them. But the most important thing for us is that you remember that you were the ones that had the relationship with these people. So they may not hear from us until they get from closing. And if they haven't heard from us, that really is the best
Scenario.
thing. Yeah. You want to hear from us and you want to be in contact with us. But a lot of times we get these emails. My people haven't even heard from you. Well, great. That means we don't have any problems.
Buyers would never have a reason to hear from the title company. Typically, they're dealing with their lender and with you. And so, and again, she's talking about seller side CD, you know, the buyer is going to get that CD from their lender, and that lender won't send it to you either. So it's going to be up to your buyer to share that with you. But on the seller side, you know, you're going to basically, once that information sheet is requested, and that's pretty standard across any title company, they're going to request that information from the seller. They're going to make that contact. But that's the only time they really make that contact unless needed. And she's right. You are the liaison between your client and the title company, not the title company. And they don't know the personalities of your clients. You do. So I think it's always good that you're the one that's making that contact.
And they trust you. You know, we call them out of the blue and we're like, hey.
What's your social? What's your loan number?
You know, Ashley and Malia, they call and they get the payoff information. They have sweet personalities. They have a comforting way about them.
They get chewed out of lot.
They get, you know, why do you need that? Well, that's ridiculous. Last title company I used didn't need that. Well, guess what? This is the title company you're using now. This is the law now. This is what we're doing now.
And you can prepare your clients. If that phone call is going to, if you have a seller, hey, they're going to call you and they're going to ask for these things, and it's okay. And, you know, it's always good if you can, like I said, find out who that processor is. You can actually say, Ashley's going to call you, or Malia's going to be calling you and asking for this. And it's safe to give her that information. I had one the other day that called me and he goes, is it okay? I told her no, she wasn't getting any information from me. And I was like, it's good. Yes, that's who you need to talk to. So.
And if we're 3 weeks into this and your seller calls and says, I haven't heard anything from the title company, and you call us and we say, well, funny thing is we have their social security number and payoff, then they have heard from the title company. We haven't coddled them and held their hand because we can't on all of them. We wish we could. We wish we could make friends with everybody. But unfortunately, with the way that the real estate business is right now, it is so busy. We do not have the option to hold everybody's hand the way that we wish that we could sometimes.
All right. So getting back to the seller side, I would say on this seller side CD, when the title company sends that out to usually it's both agents to look at it. Make sure that both sides have confirmed that it's okay before you send that to your seller, because sometimes there are mistakes. Hey, I forgot to tell you that I was going to reduce my commission to pay for that home warranty. And lo and behold, the seller has already sent that CD over, or the seller's agent has already sent the CD over to their seller, and now they're finding out that their amount's going to be reduced. Whatever. Make sure that it is correct before you share that with them. And then, like Abby and I had a deal last week where my sellers had taken off work to close, and we found out at the last minute that a lender had an issue and we weren't closing on time. We went ahead and closed the seller's side. They can sign early as long as there's no docs coming from the lender. that are going to be date sensitive. You know, there's no reason that the seller couldn't sign early. And in this time right now, with people closing in parking lots and things like that, it's really not as important that they, you know, that they see each other. You know, if they want to get together after closing, that's great and fine. But right now, it's not necessarily needed. So your seller can always sign early.
So your buyer, if you have a loan, your buyer has to sign the loan documents the day that they are dated. So if the whole time your contract expiration date is September 4th, the lender has set everything for September 4th, we've got everything prepared for September 4th, whether it's a mail away or not, your buyers have to sign and have those documents dated on September 4th, okay? Your seller can sign on September 4th or before. So if they know that they have a vacation coming up and they need to sign August 27th, party on. Now, that being said, we may not have everything finalized at that point. So like Stephanie said, our practice is to not send out the final seller CD until we have full approval from the lender. If your people are going on vacation or someone has passed away or they have to go out of town, whatever, we have to let them know. We'll go ahead and let you sign the documents, but there is a chance that this is going to change as far as the numbers, because you're signing a week early. There's a lot of things that can happen in a week with the loan, which may change your seller pays, which may change prorations, on and on and on.
Yeah. All right. What does your buyer have to bring to closing?
And the buyer always needs to bring a valid driver's license, second form of ID, and that can be anything. I always tell everybody anything other than a credit card, because I don't really want your credit card number in our files, and you usually don't want to give it to us. So insurance card, Dollywood pass, hunting fishing license, gun carry permit, work badge, yeah, anything that you've got that has your first and last name on it serves as a second form of ID. They also need to bring their funds in the form of a cashier's check made payable to Southeast Title or a wire. It is the responsibility of the lender to instruct your people what their final numbers are and that they need to bring a cashier's check or a wire. Obviously, they are going to possibility come back to you and be like, I don't know what to do. They can always call us and we'll tell them exactly how to get their cashier's check made out, or you can tell them whatever, but the lender usually will give them that information. We do not release buyer side CDs to anybody. Okay, TRID guidelines, TILA, RESPA, something, that happened in 2010 were designed to protect the buyer and the buyer's privacy. So when we get done with the closing documents before closing, you are going to receive from us a seller side CD. Whether you are the list agent or the buyer's agent, we send you the seller side CD. The purpose being is for you guys to check your commission, basically, okay? And to make sure if there's seller pays, that's listed on there as a credit or as a debit from the seller. The buyer CD will be sent directly to the buyer from the lender. We do not send the buyer CD to anybody ever, okay? The buyer CD will come from the lender. If they choose to share that with you so you can go over it and make sure that everything seems to be lined up, that anything that, you know, termite letters, whatever, taxes, all things are on there the way that you anticipated, or they need you to help explain some things to you, that is your buyer's choice. But we cannot send that document to you. So they will be sharing that with you.
A lot of new agents on this call too, when you get that seller side CD, you will look, again, buyer's agents, you will look at your commission and you will go, oh my gosh, it's wrong. It's $500 short.
Well, that's when you get the check.
Short.
So it should be right on the CD.
It should well, some of the title companies still show what they're writing out, and then they put in parentheses the earnest money.
Okay. So
sometimes your check is not going to reflect.
Okay, so for us, when we do a seller side CD, let's say your commission, total commission was $10,000. Buyer's agent gets $5,000. Seller's agent gets $5,000. Buyer's agent was holding $500 in earnest money. Okay, so the CD is going to say list agent commission $5,000, buyer's agent commission $5,000. Okay. And you're going to look at it and you're going to say, okay, that's right. Life is good. You're going to get to closing. We're going to close. I'm going to hand you your copies. You're going to have the CD that shows $5,000 each, but your check is going to be for $4,500. You're going to get in your car and you're going to whiz around over here to Realty Executives, and you're going to sit over there in the parking lot and look at the thing before you take it in, and then you're going to call and you're going to say, hey, I just left and I think my commission's wrong. And we're going to say, where's the earnest money? And you're going to say, oh my gosh, you're right. Okay, bye. Every single time it happens. Every single time. Often not only to new agents, but definitely to new agents. If Realty Executives is holding the earnest money, you are the buyer's agent, and you have collected the earnest money on your side, your check is going to be less the earnest money. Okay. So just know that, and it's okay if you call. It happens every single time. It is what it is. And it's a learning when you think that you're getting a check for $5,000 and you get $4,500. So, but that's going to happen.
All right, moving along to the fun stuff. Tax sales. What's a tax sale, Abby?
Okay, so a tax sale is in the event that a piece of property has been recaptured by the trustee's office, by the county or the city, because the owner has neglected to pay taxes.
Property taxes.
Then that property can be resold in a tax sale. If you have someone who comes to you and says, I found this piece of property, it's a tax sale, your answer to them should be,
run
like the wind. You do not want this property. Okay. It's all confusing and a lot, but.
And we say that jokingly, but seriously, because there's so many ramifications of resale. You don't want to be that agent that sells it only for your investor to find out that they now can't convey it to a buyer who's getting a loan, or they can even lose it again because the previous seller can come back and actually reclaim it.
So if the person who defaulted on their taxes, they have a certain amount of time to come up with that money and recapture that property. So there's a chance that this property can be sold on the courthouse steps to your investor. Your investor purchases it. They flip the house. They go to their
$100,000.
Yeah, they've put money into it. They're about ready to list it, and all of a sudden, Joe Bob comes up with his $6,000 to recapture to get his property back. Your investor who has put the money in this property has lost his money. Period. If he goes to, let's say Joe Bob doesn't come up with the money and he goes to sell this property, no lender is going to give anyone a loan on property in which there is a chance that a previous owner could come up with the money to pay off the taxes and get that property back. And I know this is so confusing to you guys.
To especially new agents, but it does happen. There was a property on the market last year, prominent agent in town, and basically it was cash only because they could not sell this. They couldn't offer clear title or title insurance to a new buyer unless it was a cash deal. I think they eventually took it off the market, but it was unfortunate because they didn't understand what the ramifications of a tax sale could have on them. So just be very careful. And if you have a question, come and ask the title company, whichever title company you use and trust. Just make sure that you're not getting your investor buyer into something that they can't get out of.
It seems like a really good deal for people, especially investors who purchase like to buy cheap and sell, flip and sell and do the things, but it's really not worth the risk that you're taking. And it takes 15 years basically for a tax sale to be null and void and no longer a problem. So if it's happened in the last 15 years, it is going to cause issues that we're going to have to deal with if they can be dealt with.
And I think the redemption period for the delinquent property owner is like a year. Isn't that right?
Yeah, there's some things are 1 year and then some things are 3 years, I think. Usually, so on a lot of these things, tax sales, estates and everything, it seems like each situation is different. So even though Stephanie and I feel like we know a decent amount about these things, a lot of times we're going to immediately defer to our attorney before we give you any final answers as to what we need or what we need to do. But it's not, they don't have forever to come back and recapture the property. It is a shorter amount of time. However, all these notes say 6 years definitely before even you could consider even approaching the underwriter to
But
insurance.
typically it's not cleared away until 15
Right.
years has passed.
But if you get into a situation where we have questions about a tax sale, get us that address. We'll get it to our attorney and we'll have her tell us what would have to be done, if anything can be done in order to insure it.
So you're going to get this packet in your email if you're on today's class. Megan will make sure it comes out to you. I would flag this page, this estate notes. Keep it handy so that you remember. Again, if you have questions, you can call the title company, but we're going to move on to estates.
Okay, so like we talked about, anytime there is an estate dead person involved, we need to know immediately. Testate means that that person has died with a will. Intestate means that they have died without a will. Stephanie loves to talk about this, so here she is.
Estate. Oh yeah, estate.
Are you in the thing? Can we see if she's in the room?
They just need to be able to hear me. They don't have to see me.
No, but you're so cute.
All three of you are in there now.
Oh,
Oh, we are like halfway. Sorry, it's really hard to do this without seeing you guys. Okay.
How far did you get?
We just talked about dying without a will and with a will. So we're down to probate.
Okay, so probate means the official proving of a will or the validity of a will. And what that is they will take the will itself and the death certificate and go to Blount County or whatever county the deceased resided in, and go to that probate department. And then basically from that point, the probate department up here at Blount County is really, really great. So they will provide a list to your sellers and tell them exactly what they need to do, when they need to do it, how they need to do it, etc. And then from that point on, they'll open probate. And then the inheritance tax waiver is basically an estate tax that is charged to the estate, and it's got all kinds of totals on there. I think it says 5 million.
Okay.
So, and I think they reduced it or something to 3 million or so. There's been so many different tax laws that have changed, but regardless, that is something that we can help them fight. We have all the forms there, the inheritance tax waiver and the 10K release. We can print those out. We can help them file them. They're extremely easy to do. We can send them in. None of that is really an issue. The 10K release is something that you might want to prepare your sellers for. 10K release does not mean that your seller was on 10K. 10K release is a program, obviously, that they recover their funds if the person was on 10K or Medicaid after the person is deceased. And they can, if nursing home bills were not paid or something like that on the estate, then 10K can file a claim against the estate and get paid at closing through the real estate process. So regardless of if they were ever on 10K, regardless of how much they made a year, regardless of any kind of income or whatever, anyone that dies in the state of Tennessee has to have a 10K release on their estate. Which again, the form's real easy to fill out. We can send it in. We've got people that we deal with all the time, so we email them the 10K stuff, and then they usually send us the release back for closing. And how many years has it been? The past 2 years, I guess. Our underwriter has, you don't know, has made us get the 10K release and have it back before we can actually do the closing. It used to be that we could file the 10K release for the sellers and then wait, just hold the proceeds of the sellers and wait for the 10K release to come back, and we could still close. But there have been a lot of issues with that. We had another title company that went ahead, closed the deal, and then they were holding the seller's proceeds, waiting for that 10K release to come back. the 10K release didn't come back, an invoice came back, and it was more than the proceeds that the title company was holding. So then at that point, the title company is paying the rest of the claim because obviously they closed it before they should have. So our underwriter kind of got scared with all of that because that happened more than once. So they have just made a flat out rule for us that we are not allowed to close it at all until we have that release back. So the sooner we can get it filed and sent to them, then the quicker we can get it back, and then everybody can close.
So how long does it take to get the 10K release back?
It usually takes about 2 weeks. However, due to COVID-19, it's taking at least 4 to 6 because they're short-staffed, they don't have enough staff, all of this. FedEx is slow. There's plenty of reasons, but
and Sharon, we'll answer the second part of your question here in just a second. So the big thing for you as agents to know when you go out to an estate is that there can't be any closing happen at all. None. No conveyance unless that person has been deceased for 60 days, for 2 months. So, you know, I went to a house probably 2 weeks ago and the guy said, I want to, you know, sell this house. My mom passed away. I said, when did she pass away? Last Friday. I was like, okay. You know, that can't convey for 60 days. We can be preparing for us to get it listed and get it on the market, but it can't sell, it can't close until 60 days. I know in the past, Pat has gone ahead and approved us to do a listing, but you need to make it very clear in your listing agreement that this property cannot, it's an estate, it cannot close until certain date. And then depending on whether there was a will or not, is going to dictate some other things. So if they file probate, and I'm kind of just winging it here without Stephanie, if they file probate, what happens basically is they go to the courthouse, they file probate. Once probate has been filed, then there will be a notice to creditors. That is basically, you can see the definition. They run a notice in the paper that says, this estate's been opened up, this person has died. If anybody has a claim against this estate, you've got 4 months to make your claim. So it will run consecutively in the paper. And, you know, I guess companies like that have people that watch these things. But basically, you could go ahead and close it 60 days, but nobody's going to get money. The heirs are not going to get money. The estate's not going to get money until that 4 months have passed. Now, 4 months, as I've learned, is not necessarily a hard deadline that, okay, on 4 months you get paid, because what has to happen is the 4 months pass, right, and then the attorney has to go back and check title again to make sure none of those claims have been placed.
So the 4 months passes, we cannot keep up with 4 months for everybody. So what we do is we tell your seller when they're here, your notice of creditors ran on August the 28th. 4 months from then is December 28th or whatever. So we say on December 28th, that 4 months will be up. On or after December 28th, call and let us know that 4 months has expired, and we will send our attorney to the courthouse to check and see if any claims have been filed on the property. Okay? Now, Susan has told us at that point 7 days is the time frame that we need to give her to check everything, because, for instance, in Blount County and most of the counties around here, probate court is not online or anything like that. So she has to physically go to the probate office to check this information. So they're going to call us on the 28th. She's going to check. Normally, you know, 7 out of 10 times, everything's fine. There's not been any claims or anything. We go ahead, and as soon as she gives us the go-ahead, we write their check, they come up and get it. If there are any claims that have been filed in that time that we haven't found out about up until that time, then we have to figure out how to get those paid off before we can disperse the money.
So let's say somebody doesn't have a will and they don't want to file probate. You know, I think a good recommendation would be that they probably need to talk to an estate attorney to get some good advice on that, because you're going to have a lot of places that you're not going to get maybe even a year without a will. So they're not going to get those proceeds. And the, you know, an estate attorney can help a lot with that kind of stuff. And sometimes the estate attorney we'll hold those proceeds for them instead of the title company. Because do y'all ever hold proceeds up to a year?
Yeah, I mean, yeah. So kind of like I was talking about with the tax sale thing earlier. Every one of these situations is different with estates. So we can't just hard and fast say this is the deal. I mean, there are obviously hard and fast rules. We have to run the notes creditors. We have to have 10-carry leases on most things. But if it's a husband and wife and only the wife has passed away, then we're fine. All we need is a death certificate. And then the husband can sell it without us having to go through anything for the wife, depending on if the property was correctly conveyed. So basically, it just goes back to what we said from the very beginning. Let us know the most information you can as soon as you can. We run everything by Susan, who is our attorney, and she gives us a detailed list of what we have to have and what steps we need to take to make sure that we are conveying clear title. So she may say, hey, check the probate, 10-carry lease is in there. They've already started running notice of creditors. You've got till this day. We're good, we're good, we're good. Close, you can give the money out in 2 months, whatever. She may say, okay, this estate, these are the problems. What about this granddaughter? What about this son? What about them? This person died before she did. Did they have, I mean, there's a million ways for there to be a million questions. So just keep in mind as you're doing estates, although there are hard and fast rules that we do have to follow, no situation is like the next one. So we get a rundown of what Susan needs immediately. As soon as we get that, Ashley or Malia will send out an email to you as the list agent with a list of, okay, this is, and I guess depending on, if you have somebody that's email friendly, all the things, like she may send it to you and say, this is what we need from your buyer or your seller. She may copy the seller, whatever, but you're going to get that list of what we need in order to complete everything the way that it needs to be completed.
I think in this market time too, it's really important that we get this information up front before you list it, because things sell so quickly. You sure don't want to have somebody that all of a sudden says, I want to close in 30 days and you haven't got the details back on an estate. So as a listing agent, be prepared and getting that information ahead of time before you go on the market. You're better off. And some of us get so anxious to get something up there that we forget that we have a due diligence to do. And talking about that, going back a little bit to the inheritance tax waiver, it's not the most common thing that we have big, huge estates where somebody's going to have to pay taxes. But in the situation, if you are an agent and you ever come across someone who maybe calls you up and they have a lot of property, they have millions of dollars worth of property, and maybe they say mom has been diagnosed with cancer, we want to go ahead and actually transfer her property into our name before she passes. We don't want her to have to deal with this or deal with the estate. So we're going to go ahead and have her quit claim this stuff to us. Be very careful, guys, or we're going to go ahead and have her sell it to us. If mom passes away, there is no tax there unless it's over those $5 million or whatever. But if they have now got it through a quit claim and it's theirs, and then she dies, and then they try to sell it, there could be some tax ramifications. Mm-hmm. So am I saying that right, Bill? So basically, I think you need to get a tax accountant to look at that situation if you have somebody who wants to try to sell it prior to her passing away. Because right now, they get a waiver. If they go to sell an investment property afterwards, they're going to have some pretty high tax ramifications.
I think you're better off to inherit it from a tax angle.
What my thought was. So yeah, so we've got the 1 year, and if you do have trust, they can serve first after 4 months. Are there any questions on estates? Have we covered everything?
The answer to that is no.
But you can't. Every estate is so different, which is again a good reason to send everything.
Also, and another thing, and we always tell everybody this: if you have an estate, be very liberal with your closing times, because it's going to take a little bit of time. So try not to promise somebody a rush closing if there's an estate involved, because it's just not. You're going to end up extending because it takes time to get all this stuff taken care of. So be mindful of that.
All right, moving along. Prorated taxes. What does that look like? And that's
Okay.
happening right now. That's big right now.
So technically, in Blount County, for instance, that's what we'll use because that's where we are. Blount County taxes are due on October 1st. They are late after February 28th of the following year. Okay. So in 2020, the taxes that cover the time period from January 1st, 2020 to December 31st, 2020, those taxes are due October 1st, 2020. They are not late until February 28th, 2021. Okay. That being said, Blount County, in their infinite wisdom, decided about 2 weeks ago that they were going to start collecting 2020 taxes. So they're technically not due until October 1st. They will still technically not be late until March 1st of 2021. However, because the trustee's office is currently accepting payments, if we convey property, we have to collect the taxes for that property because the trustee's office is collecting payments. Okay? So
we're not just looking at crediting and debiting people's sides. We're looking at actually making the full payment.
So right now, we would collect the full year of 2020 taxes from your seller, and we would prorate a credit to the seller from the buyer for the taxes from the day of closing to December the 31st for Blount County. Okay? Maryville City, normally taxes are due on September 1st, correct? For whatever reason, I didn't check yesterday. Are they collecting them? Okay. So normally taxes are due September 1st.
I haven't checked today. But.
They are late as of, they don't have all those months. So I think it's a month. I think they're due September 1st. They're late September 30th.
Then you have
Then you start to collect a little bit of a penalty along the way. However, this year, as of yesterday, Maryville City is not yet collecting taxes. So we are not collecting city taxes from the seller. We are assuming that the buyer is going to pay those either through their escrow account, which we would be able to see if that was going to happen because we'd know how many months from the lender's instructions they're putting in escrow, or we're going to have to tell the buyers that when they come due, the buyers have to pay those. And we are prorating a credit to the buyers from the sellers from January 1st, 2020 to the day of closing. That is so confusing. I know. I lost my fans.
And counties do it a little differently, correct? Different counties do it different ways.
Yeah. So most places around here, most counties are due October 1st. But Knox County right now, they're due October 1st. Knox County is not yet collecting them. Blount County is due October 1st. Blount County is collecting them. So for every closing, it is going to be different for basically the months of August to December. It's a total cluster. It's different on all of them. Sometimes the lenders want to collect it from the buyer. Sometimes they want us to collect it from the sellers. So it's going to be a case-by-case basis, and there's really no way for us to tell you, again, hard and fast how that's going to work out. It's just going to depend on what the lender makes us do on most of them.
And once we tell the sellers that the taxes are paid in arrears, this is the proration, then they're like, oh, okay. People forget taxes are paid in arrears, and they're collected in the middle of the year. It's real weird, but we didn't make the rules on that one. So normally after we tell them that and explain that, then they're fine with it.
It's also very confusing because when you're purchasing a home, when you're doing a closing with a loan, you have to purchase your homeowner's insurance going forward. So on the closing statement, they collect the first year of homeowner's insurance, okay? So they're going to escrow on the closing statement maybe for a month or two of homeowner's insurance just to get that rolling in your escrow account. Taxes are the opposite. You're paying backwards for time that has already passed. So a lot of times you're going to see just a couple of months in homeowner's insurance and then several up to 13, 14 months in tax escrows depending where we are at that certain point of the year. But we'll look at some statements here in just a minute that'll.
And I think for agents, kind of reflect back to what you learned in your classes, because we forget this as veteran agents, but it's not hard for you to estimate for your buyer or seller, especially if you know that you've got a tight deal. You can go ahead and prorate those taxes yourself, take the full year of taxes, divide it by 365, get a per day, a per day rate, and then multiply that by to the day of closing. And that way you can kind of give them an idea, because they don't understand. A lot of times sellers will say, well, I've already got that. That's in my escrow account. Why should I have to pay that there? You have to explain to them the title company will be required to either debit or credit you, or go ahead and fully collect that. And that should be on your net sheet. That really should be on your net sheet. It's kind of a game for me. I like to see how close I can get to the taxes, but know how to prorate those taxes to kind of help your client see what the numbers are going to look like.
And anything, so if it's this time of year and we have ended up collecting $1,200 from your sellers for taxes, and they are fighting you because that money is already in their escrow account, your people are not going to double pay for taxes. It is impossible. The trustee's office will only accept to the penny the amount of taxes. If taxes for your property are $1,408 and we send them $1,409, they send it back and make us recut a check for the dollar or for 27 cents or whatever. So at this time of year when taxes are due and they're being collected and all the things, whoever's check gets to the trustee's office first is the one that they keep. So if we have cut a check at closing for taxes, your sellers know that their escrow account has been collected on for the last 14 years, so that money should be in there. If the trustee's office gets our check first, they're keeping our check and sending back, either not collecting a check from the lender, or in the event that the lender sent them at about the same time, they're sending back the check from the lender. Your people will get that escrow money back from their lender. If it crosses in the mail and for some crazy reason the lender's check and our check gets sent at the same time and they get the lender's check at the trustee's office first, they return our check and we cut it back to your people. It may take 30 days, but it's all going to come out in the wash.
All right, we've got about 10 minutes left. We're going to cover closing disclosures and HUDs, what the difference there is. So back, how many years ago? Well,
10.
2010,
No, yeah,
10
10.
years ago.
Yeah, that's
So
crazy.
in 2010, when TRID came about for new agents, TRID guidelines changed everything for us. Everybody, maybe we start with the HUD first, it might be easier.
Yeah. Mm-hmm.
Everybody got a HUD 1. And so we all knew that your closing statement was a HUD 1. So I'm going to skip down to a HUD 1.
And they were super easy to read and understand and explain.
So this was our settlement statement, HUD 1. You basically had a buyer side and a seller side, and it was on the same document, and a breakdown on the second page. Super simple. Once TRID happened, they basically said it's not anybody's business what the buyer side looks like except the buyer. So to protect their interests, they went to closing disclosures and ALTA statements.
Which is also why we do not send you the buyer's final CD, and we do not send, and the lender does not send it to you. We only send you the seller side, because apparently that's acceptable.
So you're only now going to see a HUD 1 on a cash.
So
and sometimes investment. It just depends on your lender. But
if you use a hometown bank, like Southeast Bank,
Home Federal,
sometimes Home Federal, but sometimes Home Federal used to do too. But occasionally, if you have an investment property and it's like a hometown bank deal, you'll still see a HUD. Most of the time, we only send out HUDs for cash deals, and it's basically like Donna was saying. It's like a checks and balances. It's been so long since I've used it.
I'm pulling down to make it go up.
You have to push it down?
2 fingers.
Oh, fancy. Okay. So we have each side. So on the far left is the buyer side, and it shows your sales price, your total closing fees, and that number comes from the second page of the closing statement. Shows a total of what's due, which is the $42,836, minus the earnest money that's been paid down, minus the tax proration, Totals that 41,816. So sales price was 42,000. Your people are bringing 41,816 to closing. Okay.
And that second line, if you're explaining that to a client, this second line, like Gabby said, you're going to scroll to the second page.
And that's itemized on there.
The buyer's got their column to the far left, and it's going to be itemized, broke down, so you can see where they come up with that number. So on a HUD, the second page is just a breakdown.
And on the seller side, same thing. You've got your sales price there at the top. Then we've got closing costs. That includes the real estate commission and everything. Then the earnest money has already been paid down, tax proration. So that bottom line shows what your seller is going to get. So cash HUDs are so easy.
So easy. All right, moving back up. So if you don't have a cash deal or an investment property with a small town bank, you're going to see a closing disclosure or an ALTA statement. And it's long. You can see how many pages I'm having to scroll through just to get to the beginning. They see that this is better. For me as an agent, I think this is more difficult to look at. But
okay, so this one we've printed off our system. When you get one, or when you see one, if your buyer shares it with you that actually came from the lender, all this information here is going to be filled in that shows their full payment amount and everything. So the lender sends us their information. We compile it with our information, but we close using the document that they actually generate and prepare. Okay, so all this will be completed, and I'll show you a full payment amount, including the interest and the mortgage insurance, if there is any. It'll include the escrows and everything on there. Going down through here, this is basically like the second page of the HUD. It's a breakdown of all of the charges. So we would have all the loan charges. This would be origination, processing, all those things. All these fees are appraisals, credit reports, all this stuff right here. And then you've got our title fees. And of course, those are all filled in because we printed this off of our system. And we've, obviously we have to provide what these are. But I mean, when you see one of these, it's actually been done by your lender. All these are going to have titles, so you'll know what all these fees are for. You've got your recording fees. All this goes to the courthouse. Like this one was a Monroe County property, so all that's going to Monroe County Register of Deeds. Can they see when I'm circling the things, or am I just doing that for fun? Okay. Homeowners insurance, prepaid interest. Here's where they've started out the escrow account. So all this stuff's going to be the 720 or 732-34 will start out their escrow account. Looks like we had a pest inspection, owner's title insurance. So that 742832 is actually their closing cost on this one.
So, and new agents that are on this call today, a lot of you go in and write a contract and you ask just for closing costs and not prepaid items. You can see that the prepaid items are a big, they can be a big chunk of the escrow part. They can be a big chunk of your closing costs. So that's why it's always important to not only ask for closing costs, but also to ask for prepaid items too.
Another thing that we have determined is, and I feel like we argued about this last time, Bill, y'all correct me, but we think it's better if you put an actual number for closing costs instead of a percentage.
Yeah.
So if your sales price is $100,000, do not put seller agrees to pay 3% of closing costs and prepaids. We would prefer that you put seller agrees to pay $3,000, or don't go buck wild and put seller agrees to pay half of closing costs, or just pick a number. Put the number, stick with the number. That way there is no
question.
There's no question. There's no way to interpret that differently. Lenders struggle with that. We've had a lot of issues where, someone felt like they weren't getting things covered that should have been. The lender felt like you can include things you shouldn't have. So basically the language that you need to use is seller agrees to pay $3,000 of buyer's closing costs and prepaids. That covers everything. And that gives an exact amount. That way your seller will know the exact amount. If for some reason throughout the process, the sales price changes, it's still just going to be that $3,000 unless you change $1,000 to something else. Right?
Yes, correct.
Totally agree.
Carry on. I had one this one we were talking about last time. I had something where they put seller agrees to pay up to 3% or $3,000, something. Too much. Too many options. And it confused everybody and it ended up being a problem.
Well, and new agents, when you ask for half of closing costs, if I'm a listing agent and I get your contract and you could just ask me for half of closing costs, I have no idea who you're closing with. I don't know that lender. I don't know their fees. For all I can say, it could be $10,000 and I've just agreed to pay $5,000. I need to know specifically, and that's where it's really key for you to have a relationship with your lender and know ahead of time about how much is their closing cost going to be on this price point house. Closing costs are not going to fluctuate that much just because you buy a house, you end up getting a deal $5,000 less. It's really not going to fluctuate that much. So make sure, and if you are working with a buyer who doesn't have any money and you need to specifically ask, have that relationship with the lender where you can say, we're going to write an offer today for this amount. How much are they going to need to close? Give them the taxes, let them know where they're closing. And if your lender's not asking those questions, like what county it's closing in, I mean, I had a guy a few weeks ago from my hometown bank who had never even taken the guy's, pulled the guy's credit, taken any information, and he quoted him closing costs. And then when it came down to it, he had no clue. He goes, I didn't really say that. I just kind of gave him something in general. Well, I don't need in general. I need some specifics. So that's where it's real important to work with a good lender.
And you really need to cultivate your relationships with lenders because we see it all the time. I was doing a settlement statement the other day, and it was some random mortgage company that was going through a broker or whatever, and I was thinking, I cannot believe they are charging these people this kind of closing costs. You need to start making lunch dates, meeting lenders, having 2 or 3 in your pocket that you can suggest to people. Hey, if you don't already have a lender, let me give you a couple names. Don't ever just say one. Give them a couple options. Let them reach out to people and make that be your kind of go-to person. That way you get familiar with how much they charge. And you'll be able to better help them when you are preparing contracts. If you know, hey, they might call so-and-so for their lender, then I know so-and-so usually charges, closing costs usually end up to be about 3.5%, which again would be X amount of dollars that I'm going to put on my closing statement.
All right.
How long does it take to get a 10-care release back? Somebody asked.
We got that one.
Okay, we already did that one.
Yep, we're good. Any other questions? We're going to wrap it up here. We got 1 minute left. Again, nobody's telling you guys to tell your buyers they have to go to Southeast. They're just a great resource for our company. You're going to probably find yourself closing. They close a lot of deals, and a lot of our agents, a lot of our top agents have ownership in the company, which again is why you need to understand that affiliated business form so you can explain it. But they're a great company. They've been a part of our company for years as an affiliated business, and so they're a resource. It's really nice to be able to. And I know there's people on this call that like to use different title companies, but it's super nice to be able to walk over if you have a problem, or actually to hand something to somebody and know that they're there. And that's what I like about these ladies. So,
and if you get in a situation with a closing and you feel like something's not right, or you have a question, or you need some explanation, even if we aren't closing, we are happy to talk to you about, whatever questions that you have. Stephanie and I do not have big feelings. We don't get our feelings hurt. If you're not closing with us, but you feel like something might not be right, or you have a question that you couldn't get an explanation on that suited you, or you might need some more explanation about some things, we're always here to talk to you, and anything you need, we'd be happy to help you with.
All right. See you guys.
Thank you, Abby. Thank you, Stephanie. We appreciate you more than you know.